so amount aqua baby back into TV so this way need him say net and no face the we need
etimi e de ababo to abonten e ma obia hu inti count ahodo aye de ball chairman ntumi no e ya de se ebi wo ho a odi fo e na bi nso wo ho a wandi fo na tie otimi edi efo no eno e na court no etimi e de hu judgment aba a judgment no enye asem kotoa na judgment no a eba be to dwa no ama court dem aye butu a eno enye asem kotoa na me na wo ka say de judge no etimi a sentence chairman huntumi 20 years in prison after saying lawyers etimi ebo modern judge no e kasa say oh chairman huntumi e wogere e wo ma wo Ghana ha e na afa baabi a court no e be hwehwe ni bia obehu no entimpo se nka court no e ma na judgment a ontimi engogo nioma mu kakra entimi emfa ema chairman huntumi nanso Justice Audrey Kosivitei etimi enti asem no emwo rule say chairman ntumi enkononkonko piem 20 years ewo efiase e na afi osan e fine no die ebubo no te se count 1 no otimi fine no 180,000 Ghana cedis a otimi de ko titisika no ma eye 1.8 billion and was say chairman ntumi etimi etua now there yemko some of the videos ewa bra chairman ntumi and a lawyer for etimi appear free court and na enye asem kotwa.
And in fact, he initially prayed for more time for him to familiarize himself with the case. You know, the proceedings that went on before he took over this particular case. The court granted him that particular time, and that Attacher was well aware that the court was going to deliver this judgment. He should have told the court that he wouldn't be around today, but he never did that. And in fact, according to Audrey Kokovice, an experienced lawyer judge here at the High Court, she said if Attacher had told the court that he wouldn't be around today, then the consultations would have gone on, and in order to set an appropriate day for this particular judgment to happen, but he never did that. So it was incompetent. It was smooth lawyers or for Attacher to even write to the court and tell the court that he wouldn't be around today. So the judge simply dismissed that particular letter as well, and then went on to read the judgment. It took more than an hour basically reading this particular motion, and when she read the motion, the judgment point, she clearly said that based on the evidence adduced by the prosecution, Chairman Wontumi was found guilty in the charges that were slapped against him. And Mame, and the prosecution called 4 witnesses. The defense, that's Wontumi's lawyers themselves, also called 5 witnesses, including Chairman Wontumi himself today. And the judge basically said that the prosecution was able to adduce sufficient evidence that meant that Chairman Wontumi would be convicted. When she was done reading the judgment, basically, so when she was done reading the judgment, the counsel in court today, who was holding the brief of Samuel Attacher, Charles Boachi, was on his feet, and he sought litigation. He sought to mitigate the process, in order for the court to reduce the number of years that Wontumi would get at this particular point. He did that. He was so nervous whilst trying to plead the court to reduce the number of years. His hands were shaky in that particular process. He did that after a few minutes, and then another person who also rose on his feet, he also mentioned the fact that he wanted to explain to the court that Chairman Wontumi has a lot of businesses, and for that reason, if Chairman Wontumi is eventually sentenced to so many years, that could affect all of that. But let's listen listen to one of the lawyers who was in court today, just to appreciate what he makes of this particular process.
We are around that. Because, yes, I do appreciate that, yes, there are situations where the veil of incorporation could be lifted and directors could be held responsible. It is not in all situations that those things are applicable. So I'm sure it's an area his lawyers would have to look at and see if it will open up some areas of appeal for him. But I'm a bit worried and a bit sad.
An offense that the minimum is 15, maximum 25. The judge, I think, might have listened to your plea, don't you believe?
Probably she did, probably she did not. Because I was of the view that the minimum sentence was okay. Because I made a point that getting wontumi out of the picture, that is incarcerating him, may affect a lot of minimum of sentence. That was what I did. I don't
argument that it should be as a deterrent sentence to persons, especially the fight against illegal
considering
mining.
the way
you see, I am not in any way encouraging anybody to go into illegal mining. And for me, the point I was making is that yes, Mr. Wontumi may have committed the offense, but it was the bigger picture I was looking at because he was going to be sentenced anyway. So my mitigation was to reduce the sentence. That's all. It's not to put in a defense for whatever he might have done or not. Exactly.
What is your relationship with Wontumi?
I thought he would have been given the barest minimum.
What is your relationship?
I don't know him from anywhere. Probably we just share a name. I'm Bernard. Is Bernard. I have no relationship with Mr. Wontumi. Maybe because he's my namesake. But I only felt that as a lawyer, these things happen. It's not because it's Mr. Wontumi. There are times when you are in court and you feel like you need to probably intervene as a friend of the court. That is something we do out of ordinary practice. It is not because it was Mr. Wontumi. We have done this several times where we believe that we need to add our voice in mitigation. Remember, it is not against the conviction. It was just to intervene with the number of years he was going to be given. So it was against the sentencing that we were trying to mitigate, that the court should give him the barest minimum. It was not against his conviction. So it is not as if I did that to probably encourage illegal mining. No. It was just for the courts to understand that Mr. Wontumi is just not like you and myself. He owns a lot of businesses. So the court, I don't know if she considered that, but well, I'm sure his lawyers would advise him accordingly.
So that's
allow me to go.
Bernard
Oredu there talking to the press at the Accra High Court. Basically, he was one of the lawyers who was on his feet in criminal court and in fact, in his arguments in court, he told the judge that Wontumi has so many businesses and that if his sentence, if the years are too many, that could cripple some of the businesses, and many of the people who are currently employed by Tema Wontumi's companies may lose their jobs, among other things. But the judge, in her, concluding part of the judgment, said that this is to serve as a deterrent to other people who are currently, involved in illegal mining, and went ahead to give Wontumi, or to sentence Wontumi for 20 years. But it was very interesting, Mami, in court today. In fact, Wontumi himself, in the process of the judgment, whilst Audrey Kokovite was reading the judgment, so he was clearly, shaking his head repeatedly in apparent disapproval of some of the things that the judge was talking about, and he was also consistently looking at the people who were sitting in court and basically, laughing and all of that. So at the moment, it is clear that the court has now made its determination in this particular matter. And in fact, some of the interesting things that have happened in relation to this particular trial is that
for videos, and I who say a chaguno, natural say court to them. Etimi aye butu no enye asem kotoa chairman ntumi ejebo judgment no ababedu chairman ntumi ekwa serve 20 years in jail after say judge no kra etimi ede judgment no eba beba no ntumi a lawyer for etimi epa ne chew say ntumi wo yere ewo ma esa wo business bebre ho asa wo de no kra kopie mu ewo afiase mfie pia eyade se betimi aha chairman ntumi na afi na busuafo ntinka court ne kra nhwe ne nka jail term ne kra enka onya hu bibi kakra nanso judge no etimi ebu nua egu na sum me no ekasa de odi chairman ntumi ekwa akopie mu ewo afiase for 20 years na ntumi lawyer for ni bi nso kasa de enko
case, and they are coming out and taking the leave from the court premises. So the conversation will largely be on social media. and reliant on outlets like ours to inform them. Now, the difficulty or the only thing we should be worried about with that social media conversation would be the likely misinformation that this would generate. And that is why we have to be timely also with our broadcast, so that people do not get misinformed in their efforts to follow the live feeds and to understand what really is happening in real time. The social media conversation is such a way that you would often have people who jump onto it. They jump onto it from all sides. They probably don't even understand what exactly it is. You just mentioned count 4. What does that mean to the ordinary social media person who is following the conversation? May not understand, but will jump onto it and try to interpret for his or her followers. That is where the real danger is. Again, as to whether the party members are massing up elsewhere, maybe there's some communication to them to meet somewhere else, maybe at the party office, that we do not have information. But within the immediate precincts of the court complex, we don't have such people gathering. We don't have them. And as I said, even the security detail here is not so heavy. That probably is because intelligence would have suggested that we don't anticipate any massing up of people, any unnecessary commotion and all of that. People are following, yes, largely from social media, largely from our own outlets. And we'll just encourage all those who are following to follow us also on our social media platforms for detailed, accurate and fair reportage on what is happening here at the High Court complex.
And just to also bring up to speed what we're also monitoring from the courtroom as this judgment is being given, we also know that referrals have been made to IDs that are said to have been not only misplaced, but more importantly, seem to have been faked as well in relation to the interested persons in the matter, as well as related to the directors of the company as part of those accused in this case as well. And then moving on to the subsequent issues, it also means that the interested parties would have to also be aware, or all interested individuals for this matter will have to be. This is what we're going to do. We're going to make sure that for all those interested stakeholders and politically exposed persons, either close to the accused persons or the company or the entity as part of those accused in this case, we'll make sure